In a wrongful death case in New York, can I have the wife testify about what the husband said minutes before he died? Would you like to learn the answer? Come join me as I share with you this remarkable information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So the answer is maybe. But now, here's the problem. The problem is that the husband died, right? So now the wife is going to get up on the witness stand and now testify. If she were to testify about something that she heard the husband say, that would immediately be known as hearsay. Now, why is that? Well, it's because the husband cannot come into court and now testify for himself about what it was that he was saying. And now the defense attorney is also at a disadvantage because he can't question the husband who has since died. So now anything that the wife says about the conversation she had with her husband might be considered hearsay. In fact, it likely will be considered hearsay. But now there are certain exceptions and certain instances where that type of information might be allowed to come in. So let's say, for example, this was a tragic car accident case, and the husband's driving, he gets hit by a car, the wife is in the passenger seat. And now, as the wife is trying to figure out what's going on immediately after the accident, she's talking to the husband's in excruciating pain, and he says some things like, "Tell the kids I love them so much," something like that. And now, that might be known as an excited utterance, where he knows that his time on earth is limited, and he's got only a few moments to spare. And now he says something to his wife that he ordinarily would not have said at that moment. In certain limited instances, the court may allow that type of information to come in under an exception known as an excited utterance. For the most part, though, where the defense no longer has the ability to question the person who is making those statements, and now you have the wife or some other relative or friend talking about what that person who died said, that's automatically considered hearsay and would not be allowed. So why do I share this great information with you? I share it with you to give you an insight and an understanding in some of the things that go on during the course of trial. You know, I realize you're watching this because you probably have questions or concerns about your own matter, and whether it's a malpractice matter, or whether it's a car accident matter, or even a wrongful death matter. If you do have legal questions and your matter happened here in New York, what I encourage you to do is pick up the phone and call me. You know, I answer questions just like yours, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.